Hello, thank you for joining this MBL webinar. My name is Leah Alprin-Waterman and I'm a knowledge lawyer at Mishcon de Reya. In today's session, I'm going to be looking at recent developments in relation to the principle of legal professional privilege. The aim is that by the end of the session, you'll have a practical, up-to-date understanding of the risks that AI tools pose to privilege, the ongoing issues arising out of the restricted definition of client in a corporate context for the purposes of legal advice privilege, the abolition of the shareholder rule, the position of litigation funders and other third parties when it comes to litigation privilege, the operation of the iniquity exception and the problem of privilege hunting, and the risks of inadvertent waiver and how to avoid them. But first, although this session is not intended to be a back-to-basics tour of the laws on privilege, let's start with a quick reminder of the fundamentals. Legal professional privilege has been described as a fundamental condition on which the administration of justice as a whole rests, and a fundamental human right long established in the common law. It's made up of two categories: legal advice privilege and litigation privilege. Legal advice privilege covers confidential communications between a client and their lawyer made for the dominant purpose of seeking or receiving legal advice. Litigation privilege, meanwhile, covers confidential communications between a client and their lawyer, or between either of them and a third party, where the communication is for the dominant purpose of actual or contemplated adversarial litigation. These definitions may appear deceptively simple, but their application can be notoriously complicated, as we shall see.